Hi, my name is Kaisa Krusko, and I am a family law attorney in Bedford, New Hampshire. This segment will focus on the relocation of the residence of a child. Relocation in New Hampshire is governed by RSA 461A12, unless your parenting plan has agreed to a different standard. Parenting plans do give parents the opportunity to agree to a different standard, but most parenting plans will have checked off the standard enumerated in RSA 461A12. The relocation of a residence of a child will govern for a child's residence where the child resides more than 150 days in the year. The relocation statute will not govern when a parent is moving the child either closer to the other parent or it does not change the child's school district. For example, if you live in a town that has a regional high school and you move to the next town over, but the child still attends the same high school, then the relocation statute is not triggered and you may move without the permission of the other parent. However, if you are moving either farther away or where there is a change in the school district, then the relocating parent must give reasonable notice. Reasonable notice is often defined as 60 days. Once notice is given, the other parent may have the opportunity to object, and the statute says that either parent may then ask for a hearing on the relocation. At a hearing on relocation, the parent seeking permission to relocate must prove and demonstrate by a preponderance of the evidence, and preponderance of the evidence is a legal standard meaning more probable than not that the relocation is for a legitimate purpose and that the proposed relocation is reasonable in light of that purpose. So, for example, if a parent is seeking to relocate for the purpose of being close to friends and family and having a support network, if that parent's friends and family live in Florida, but the parent is seeking to relocate to North Dakota, then the court would possibly find that that move is not reasonable in light of the stated purpose. So if the parent who is trying to relocate proves those two things, that the relocation is for a legitimate purpose and that the proposed location is reasonable in light of that purpose, then the burden shifts to the other parent to show by a preponderance of the evidence, again meaning more probable than not, that the proposed relocation is not in the best interests of the child. The statute does not set forth specific factors discussing best interests of the child, but there are several cases in New Hampshire, including the case of Tomasco and Fofer, that give you a good idea of what the court might be looking for in looking for evidence about legitimate purpose, best interests of the child. When the court considers what a legitimate purpose might be, that could be the opportunity for a new job that is better paying, that would allow that parent to be self-supporting or provide a better economic opportunity for the family. The court may also look to other purposes, such as being close to a network or friends and family that could support the parent. Other things could be an educational opportunity. Perhaps the parent has an ability to attend a prestigious university, and that opportunity could only be had in that different state. For example, moving to California to attend a program at Stanford. That could be a legitimate purpose. The court is going to look to each parent's reasons for seeking or opposing the move. The court will also look to the quality of the relationship between the child and both the custodial and the non-custodial parent. If the parent who has only parenting time but does not have residential responsibility doesn't visit often, doesn't attend extracurricular activities, doesn't attend sporting events, doesn't attend school events, then the court may consider that in whether or not that same quality of relationship, so maybe talking on the phone and seeing the child every so often, could be continued if the other parent relocated. Which leads into the next factor of whether or not the impact of the move on the quantity and the quality of the child's future contact with the non-custodial parent. And that is often going to be determined by how far away the move is. A parent who moves to Massachusetts or Connecticut is going to still be able to maintain some kind of frequent and continuous relationship and parenting time with the child, whereas a move to Texas from New Hampshire would require plane travel, and it would be unlikely that the non-relocating parent would be able to have monthly or weekly time even with the child. It would be more often vacations and summertime. So the court will look to that and see what the impact of the child will be. The court's also going to look to the degree to which the child's and the custodial parent's life may be enhanced economically, emotionally, and educationally by the move. So, as I was discussing before, is there an educational opportunity that would be beneficial for the family? The court's going to look at the negative impact from any continued or exacerbated hostility between the custodial and the non-custodial parent. So in that kind of situation, would lengthening the distance between the custodial and the non-custodial parent increase hostility between the parents so that it was more difficult for the child to have a good relationship with each parent? And it would also look at the effect on the move of the extended family relations. So if all of the extended family relations were here in New Hampshire, so grandparents, aunts, and uncles, and the child were to move away from New Hampshire and not be able to continue that bond that the child may have with the extended relations, the court's going to take that into consideration. If you have any questions about the relocation of a residence of a child, please feel free to contact my office for further information.